Boom. All right, so now we are recording. So once again, thank you guys for coming on and jumping in here with us live with, to my left on the screen, it would be Mr. Stephen Cho of CKBVN. I want to give us a little shout out, Mr. Steve.
Hello, thank you for having me, Ryan. I really appreciate it.
Oh, my pleasure, my pleasure. So we're excited to have you on here today, trying to answer some questions. You will find that there's going to be some people that may ask questions here inside of the Zoom meeting itself. Victoria is also watching with us as well and watching on Facebook to see as questions come in that we are able to answer those questions. So we'll try and do our best. But Steve, what kind of law do you do and do you practice, just so people can get a chance to know who you are and what you do?
I primarily practice real estate, mortgage law, as well as employment law. Those are the three areas I primarily focus. However, we have a full practice law firm where several of our attorneys do family law, one attorney does tax, and
right.
We also do transactional, where if you're buying a business or selling a business or looking at real estate transactions, right. We review documents and advise clients to avoid lawsuits.
Now you're just out of law school, right? Like you've been doing this like 6 months or so, I think, right?
I'm approaching a little over 19 years.
Yeah, so you've been doing it a bit, and I think some of the folks in the local area may know you, may have come across you as well. So we definitely appreciate what you've done and being able to build up the firm that you guys have. I know we partnered up with you on a number of different presentations on different very topics, but tell us a little bit more about what you think is pressing for today, and maybe even just like a little bit of a teaser, especially for those that might be watching online. Like, hey, I don't know if I should watch this whole thing or if I need to come back and watch it later. What does that look like?
You know, I think everyone's looking for an opportunity during this crazy times. And, you know, sometimes opportunities are not readily available or known at this point. But what I've found in our firm is we've taken this time to really relook at the way we do business, relook at ways to streamline process. And one of the things that I thought that popped into my mind when you contacted me about the seminar was, if we can take the time to really give some of the agents the landscape of administrative law, what DRE accusations entail, and things that we can do now and implement system. And when something does happen, when a lawsuit or an accusation comes in, they can save a lot of time if they have the infrastructure put in place. So I thought the area of opportunity now might be to kind of revisit the way they're operating and revisit ways that they could eliminate some of the liabilities and kind of operate what lawyers call practicing defensively so we can avoid malpractice. Maybe the agents can adopt those similar principles and practice defensively so that when you have unrealistic clients that may make accusations, that we can pull out an email and say, no, that's not true, and you can defeat those claims that are coming in. And maybe, you know, that adage of it's not what you make, it's what you keep, or what you save is what's real the profit. Maybe in this scenario, right. If they can figure out a way where in the future they can save time, not having to those documents, not, you know, understanding things so that they don't get themselves in a DRE court where their license is at stake if they don't have to waste money on lawyers. That's all safe profits. So maybe that's the area that I could maybe kind of educate and to just talk about, to give some reference points so they can look into it further and develop their overall expertise in this area.
Now, as we're talking about that, you bring up obviously the courts, attorneys, courts, obviously synonymous. You know, that's where things are practiced. Sometimes it goes into court, sometimes it doesn't. Has COVID in any way, shape, or form affected the courts? Are they still open? Are they still currently hearing cases?
No, the courts are closed right now. As a matter of fact, I was representing a mortgage lender in a jury trial in San Bernardino Court on March 16th. And we were scheduled for a 12-day jury trial. We were in day 5, and the judge stopped us in about 10 o'clock and said the presiding judge shut down the court, so we're declaring a mistrial. So he literally had to stop everything, and I think the client that I represented probably spent about $15,000 a day for 5 days, and now we have to start all over again. And we're gonna go back in probably June 22nd to see where the courts are at. But it looks like the courts in San Bernardino are doing what's called a soft opening, where we'll be able to file documents in June. We'll be able to, they're even talking about alternating court rooms where, you know, the one courtroom will be open Monday, Wednesday, Friday. Another one across the hall will be open Tuesday, Thursday to limit the amount of people and maintain social distancing. So it's really affected, I think, the lawsuits and real estate agents as well as brokers and lenders. But it really didn't eliminate the problem. It just kind of kept everything in a queue that's just adding up. So I think there's going to be a big shift coming up sometime in July, August, and I don't know how that's all going to play out. But right now we're on an extended holiday. LA County, I think LA County just notified us that they're shut down until June 22nd. And they're going to start doing also a soft opening, and they're doing a lot of hearings via a court call, conference call, basically, for the courts on the record, and they're trying to eliminate that. And it really puts some of our clients at a disadvantage, I think, because when you're being accused of some type of misconduct, you want to bring the accuser to court and put him under an intense cross-examination. And if you had to do that over a conference call, it really eliminates some of our tools available to us. So I'm advising our clients to push it out until we can actually have a live hearing.
Okay. Well, let me ask you a question then. Do you think that these cases and these things are just going to go away, or are these things going to build up? Is there going to be a huge surge in items once the courts open back up? What's your thought on that?
So about 15 years ago in Riverside, there was a DA that wanted to become Attorney General, and he demanded no settlements in the criminal case. And why I'm bringing that up is that the criminal defendants have a right to a speedy trial. And what it ended up happening is all the civil trials in Riverside got suspended so that the civil courts handle criminal, which meant a civil case that normally would take a year to 2 years to get to a trial. Now we're looking at 4 to 5 years before it gets adjudicated. So what I suspect coming up is that these cases are not going away, and these cases are going to continue to be pushed through. The difference is now it'll take 4, maybe 5 years before we actually get to trial.
Hey,
Well,
that's bad, right? Because then aren't these businesses and some of these realtors kind of put at a stay where they can't work? Or are they still able to work during these times, or brokers? What's the implications on that?
I mean, if they have their license, they'll be able to work. I mean, the civil cases we're dealing with the monetary and civil remedies, but I think the DRE and the DBO, they're doing the same concept where they're holding everything off until the governor's stay-home order is lifted officially, and it'll come back and it'll just delay. And you know, real estate agents, unless there is an order where your license is, you know, suspended immediately, you'll still be able to work. It's just having this monkey on your back that you're having to deal with for 2-3 years. It's not an easy place to operate. So I think it will affect the agents and the companies overall.
Okay, so let me just turn it over to you. Obviously, there's a few things that are probably pressing or most high on your list of items to address. I also want to open the floor throughout the meeting, or even towards the end, as to if people have questions. Is it okay if they pose the questions? They can. Some people might do it on Facebook, so it's going to take us a minute. The best bet, obviously, is if you're on the Zoom itself, you can put the question in the Q&A field, so we make sure we do not miss any of the questions you have. But what are the top 2 or 3 things that you're seeing that you think are some of the most pressing messages that we need to get out to our realtor partners, our real estate professionals?
So let me give you a brief background of the administrative process and the civil court process. And everything is basically rooted in proving up a particular act or proving up that it didn't occur. And everything goes back to what we call evidence. So in terms of a real estate DRE accusation, I'll start with that. There's actually a courthouse in downtown LA. It's called the Office of Administrative Hearing, and they handle claims against corporations. They handle claims against insurance agents, escrow, as well, everything but the probably attorneys and CPAs.
Okay.
And when you get there, there is actually a prosecutor. They work for the Department of Real Estate. They are very similar to the district attorneys, and they're gonna write up an accusation, which is essentially a lawsuit. And in that accusation, they're gonna lay out various facts that occurred during the transaction, the misconduct that they're alleging, and the reasons why the license needs to be revoked or the license needs to be suspended, or whatever the remedies that they're asking for, along with fines and penalties and attorney's fees. Now, when that gets filed, you have a certain amount of time to respond. You have a certain amount of time to request discovery documents and information that they have to turn over. And you're actually in front of an administrative law judge. They are exactly, when it comes to that field, they are a judge like any other judges in the Superior Court. They, I think, even get paid the same amount, and they have a courtroom they wear a black robe like any other judges, and you're gonna have a trial where you're gonna be able to put forth your defense and be able to call witnesses and produce evidence to show that that's not true or that didn't happen. And along the way, like in a criminal case, you'll have opportunities to, discuss negotiations with the DRE attorney and work out some other alternative remedies instead of having to go to trial. Now, whether dealing with it in that field or in a civil or criminal, you have to be able to have your files ready. You have to have your documents ready so that if it's a false allegation or a misunderstanding, you have to create your narrative in being able to put forth your defense. What I have found in the clients that, especially during this time, when we've had clients get sued as early as March, late February, and we're in the early discovery phase where we say, give us all your text messages.
Right.
Give us all your emails. Give us your file. And it's been 3 weeks, 4 weeks, and they're technically working, but not at the office, and they haven't been able to produce it to us because they're still looking for it. And
so I guess let me ask a question. I'm going to interject if I can and not be rude. You're saying that text messages are something that's good to keep on that deal, and how are people typically, like, let's say, for example, they delete their text messages because they get so many on there. Now they don't have a record of that. Is there a way that to get them back?
So some carriers have up to 3 months to subpoena those records, and most of the subpoenas that I've sent out, we haven't been very successful.
Okay.
So yes, California Evidence Code allows for certain instances where text messages are actually admissible. So the courts treat text messages like any other document. It's like, I'm sure you've heard of hearsay, Ryan, where if you watched any legal shows, it's hearsay. Hearsay literally defined as an out-of-court statement used for the truth of the offer asserted. So essentially what hearsay expands in an electronic technology sense, where email is a document, a text message is a document for the purposes of hearsay. So sometimes hearsay is not admissible, but if you're trying to use hearsay for impeachment purposes. So for example, if you, Ryan, accuse me of doing some misconduct, and then I have a text message from you saying, no, that didn't happen, then even though it's hearsay, I can use it for the impeachment purposes. So I find it really strange that 80% of my clients can't give me their text messages. And I say,
so what are some things that they should be keeping text messages on, or what are things that they should or shouldn't be doing as it relates to via text message or email? Like, what things do they need to make sure that they're covering the tail, or is there a case or two that comes up recently that you can reference that it's more tangible for our audience?
So a lot of times when I had a case recently where a real estate agent was being sued for fraud and misrepresentation. And it was literally a work of fiction, the lawsuit. And we eventually got it dismissed, and we were able to win on a motion for summary judgment. And it was the broker as well as the agent. But what really churned for us was he saved every text message. And we probably gone through 9 months worth of text messages, and in there, and laying out the context, we were able to find that there was a clear way to show that what the allegations were in the lawsuit wasn't true. And
Like, what was the lawsuit? Are you able to say like what the lawsuit was about specifically? And this one doesn't have to say who it is, but
it was regarding the pricing. The agent was accused of basically, it was a conflict, it was a dual listing, conflict of interest, and the seller was unhappy because the agent allegedly manipulated the price or lowered the price without advising the seller properly and notifying them that, hey, the seller basically in a nutshell said that I could have sold the property for 30% higher, but you told me that I didn't have any choices, so I ended up selling for less. I'm suing you for the difference. And because the buyer was also represented by the same agent, now it just sounds bad because of the dual agency and the potential conflict of interest, but the text message clearly showed that the house wasn't selling, and that the value, it was overpriced, and then the seller actually acknowledged that, yeah, let's just get it sold. And that text message really clearly established that the innocence of the agent. Now, if you didn't
well, I
have
guess it really comes back to speak to our audience here. So if you're watching this or you're just jumping on Facebook, maybe you want to go back and watch the last 5-10 minutes of it to hear what we were just talking about. But man, keeping that stuff documented. When you're talking about price things, obviously, it's a big reminder. Put it in an email, put it in a written letter, put it in a text message. But if you're going to do it on these contractual kind of things, obviously it needs to be retained and or saved, right?
Yeah, absolutely. And there's PDF programs that allow you to download text messages. So I have 2 phones. I have one for personal, and I have one for cases that I'm working on with clients. And as soon as I think I'm gonna, every so often, I download all the text messages, keep it in a file, because you don't know what you're gonna need it. Because for us, we think you should save everything. And literally, do you really want to save hello, how you doing? But you never know what becomes relevant, because one of the biggest complaints about lawyers from the state bar is that we never call our clients back. And if you get and I kid you not, I've had friends that actually got reported because one of the biggest claim was they never called them back. Well, if I have text messages saying, hello, I called you back, whatever it is, I mean, that clearly shows that's not true, but you would never think you would need that. But we're in a very litigious society and times, and I think the other trend that I see is that when pressure like economic factors come out and when recession starts taking hold, I think there's going to be a lot more lawsuits, a lot more accusations. So I think the agents and any professional for that matter really have to practice defensively. And that means any documents. And I kid you not, the text messages are very relevant. I have used text messages in so many cases where you put a client or a witness on the stand and they make up their story and their narrative, and then you bring out the text messages and you cross-examine them in front of a jury. It really makes them look bad. And if, one thing that jurors hate.
Oh, wait, let me pause you for a second. So it also is a point of caution to say, it could make anybody look bad. It could make either side look bad. And remember that whatever you're putting out there in an email or a text message could be used against you in a court of law, like listening to you on a deal. So let's say this case was the consumer was in the wrong. If you, the agent, are doing the wrong step as well, people come back with their text messages and share, please know that that's a double-edged sword that could be there, right?
Yeah, and what I tell clients and advise them during any transaction, and again, this is universal, not just for the real estate agents or the lenders, but it can work in any type of litigation where anything you write, you have to approach it as though an administrative law judge or a judge is going to potentially hear it and read it. So it forces you to exercise more caution, exercise more discretion, because if you don't do that, it could also turn around and bite you as well.
Right. Hey, so you mentioned that you have a tool or something that you use that allows you to be able to download your text messages and save them in a PDF. Is that like an app, or what is that?
It's a program. I am not a tech person at all. I mean, I had to learn how to even figure out Zoom. So, but we have someone in our office that actually downloads all the text messages, and I just give them my phone and they do it. And it gets into a very readable with date, time, and it makes it really easy to bring it out in a court format. So
I'm pretty sure that myself, as well as others on this call, or people that are going to watch it later, are going to be interested. So if there's a program or whichever that I can grab from you later, the name of it at least, I hate it because I get hundreds of text messages, I feel like, a day. And so I like to clean mine out. So once I'm done doing everything in there, rarely do I ever save the whole feed because I feel like my phone's going to get full. So
I agree. But at the same time, I mean, you know, if you got sued and if somebody says that you made some statements or you made some crazy allegations or whatever it is, that context of the entire feed could be very helpful in illustrating who's actually telling the truth.
Right. Absolutely. Absolutely. So that's that part. What else? What else is going on that you're seeing? How can these agents go out there and protect themselves in addition to that? Or what's another case that you might have had recently?
You know, I think it's not something that we can just point a finger and say, this is what you need to change or fix. I think in addition to having a better document retention system, I think the agents have to really take this time to really develop their art, develop their skill set. And, you know, for me, we've taken additional training classes right now to, you know, the Zoom's amazing and online resources are amazing. And, you know, typically I would bill 8 hours a day working on cases now. I'm probably billing 3, but I take that extra 5 hours and apply it to something else to really hone in my skills. I'm trying to become a better public speaker. I'm even looking into training classes to possibly start when the state opens up, where there's a trial class that I'm gonna take. And you would think that after 19 years of practicing that I would be competent at it, and I think I am, but I think I can get better. And so I'm looking at different avenues to expand my skill set, and I think the agents have to kind of approach it the same way. But, you know, I'm not probably not the person to talk about areas of opportunity to improve their business because, you know, I'm not a real estate agent. What I deal with is more of the aftermath of any kind of the breakdown in relationship with clients and consumers. And when they resort to lawyers, then it becomes more of a process of limiting liability. The other thing that I think most agents and brokers should probably start doing is create a relationship with an attorney. There are several real estate agents that hire real estate attorneys where they're not necessarily, it's not me. I have several friends like, you know, John Mansour is a good friend of mine. He does real estate. There's several that's even in this area that we are all good friends and they're all competent. And, you know, I think the process that most people don't kind of sit back and think about is you want to deal with this preventatively versus, like I always tell clients, you go to your doctor every 6 months to a year to get a checkup. And you're hoping to do that so that you can make sure that you can catch things early on. I really think most people don't do that enough for the law, where I'm not saying, you know, call them every day to figure out if you should, you know, go outside the house or not. But I'm saying to the point of, hey, I'm going to sign this contract, or I'm going to hire this agent, or I'm going to fire this agent, or I see red flags with this deal. Should I do dual agency? You know, I can double in this deal and I can make more, but are you taking the precaution to document that so that if things go south, are you going to have the resources and the ammunition to say, no, it didn't happen? Because there's nothing wrong with double ending a deal. I think you should try at every opportunity, but I think you should document that. And what the DRE requires in terms of dual agency notifications and waivers, I don't think it's enough. I think there needs to be other, emails that illustrates the risks and liability associated with that. And even if you communicate and keep everybody on, so to speak, like keeping them abreast of where things are at, saving text messages and emails and having that, I think will really aid. And then even having a quick call. And I've
So
talked
there's
to
obviously a higher risk when people are doing dual agency. Are there any other forms or documentation, or do you put stuff on a letterhead and say, hey, look, here's a disclosure between the two in addition to the car forms to help alleviate some of those risks? Is that something that you're able to do?
Well, yes, and it's kind of a situation where it's not like a cookie cutter, you got to do A, B, and C, because you got to remember in contract law, you can have a agreement written in a napkin. And if all the elements of a contract exist, the court will honor it, just like a car contract. What the car contract does is they looked at it and they're trying to create a one-size-fits-all where they at least have the minimums of what's required in disclosures. However, every situation is different. That's why I think, I had lunch with John Mansour a couple of months ago, and he was saying that a lot of his clients, the brokers, would call him on just routine matters just to make sure that they knew the answer, but they still wanted to touch base just to make sure that they're not missing. And, 99% of the time, it's exactly what they thought it was, but that 1% they catch something, they save themselves a couple $100,000 in legal fees.
Right.
So I think it's really a system of keeping your text messages, keeping your emails, keeping your letters, and even a conversation log. And I've seen some agents keep conversation logs, but what ends up happening in a trial is that there are times when you get asked about questions about events that happened 3 years ago.
Okay.
And I don't know what your memory is like, but I don't know what I did yesterday. And I don't know what I did for lunch. But now, if there's no text messages and there's no emails, there's no letters, and then someone's asking you about what you did and who you talked to 3 years ago, you can pull out your log and say, well, I know I talked to him on that day. How do you know? Because I keep a log of everything.
Right. Well, I use for example, I use a CRM. It doesn't track everything. Like it won't track, unfortunately, the text messages unless someone responds back through the CRM. On that specified number. But on traditional stuff, on emails at least, I know that without even thinking about it, it's going to track the conversations back and forth. And so that's one of the ways that I'm able to keep a conversation log to remember what we have or have not done. So obviously that's kind of a good idea, I would imagine.
But some of our clients have softwares that they use where it tracks every phone call received and every phone call that goes up. I guess that's the same program you have. But in addition, in addition to that, in that system, they can put a quick blurb about what they talked about. And when they have that, and later on, when you're in trial 3 years from now, and what you discussed really is relevant to the issue at hand, a jury looking at that and looking at the log, looking at the database that you have, and then you're allowed to use those documents to refresh your recollection. And if you do that and you sound credible, 9 times out of 10, the jury's gonna follow your version of the events. So keeping track of conversation log, and then sometimes people say, well, I don't have the money to buy software. I have had a client who was a former detective, and when he worked as a detective, he would keep notebooks, and he would write down date, time, what he talked about, date, time, what he talked about. He would keep his notes. So when he became a real estate broker, he did the same thing. And then a lawsuit came in, and they were asking him, so what happened 2 years ago when you talked to so-and-so? What happened then? So he pulled out his notebook and said, well, I talked to him about this. And how do you know? Because I wrote it in my log. I said, well, did you just make that log up? No, because he pulled out, I talked to so-and-so on this date, and he had like 4 or 5 boxes of notes where it just was incredible that he would make that up. You can't backtrack 3 years of communication. So when he said that, the other attorney was kind of dumbfounded, like he actually wrote everything down. And then he had a corroborating witness that said exactly that, and the case was dismissed. So I think a conversation log, and to me, keeping it on a Microsoft Word isn't as effective. I think a handwritten journal where you put date, time, what you talked about, who you talked to, and then keep on keeping a running tally. So if anyone questioned the veracity of that log, you can bring out the other log that it'll fit into place with the timing of it. Because before I get into that issue about the log, I would ask, do you keep a log as your daily work? Yes. How do you keep it? Do I keep it from this? And then I will bring out the first day of the log, and then to the end, and then in the middle, there'd be the relevant information. And it'd be very hard because those are all subpoenaable where, like people don't realize this, but a police officer's notebook is also, you can subpoena that. So if you keep a detailed log, an organized way of keeping track of communication, text messages, emails, letters, and even documenting what you did, what you said, what you heard in an organized manner, and then keep it for at least 3 to 5 years afterwards, I think it really eliminates any stress, any waste, any possible liability. So I think that the hope that I want to get across today is more about figuring out a method of operation that is defensive and that eliminates future liability. Because at the end of the day, if an agent is dragged into DRE or a DBO or even a lawsuit, I think the time and the stress will affect their business.
Right. So somebody was asking on here, and I think we kind of talked about it a little bit. They're asking in regards to any recommendation on software specifically as a real estate agent. So forth. I know, for example, Lion Desk is one of the tools that's out there with emails and or text messages that you do from the system and the replies that you get from the system. If you text from it, it will absolutely keep a log of both your emails and your texts. When it comes down to phone calls, most CRMs do give you the opportunity to call out now from an app. So it'll register the call, and then it's up to you when you finish that call. In most instances that I have seen, that will give a summary of what the call was about. So it's just about being due diligent, using due diligence to update that information. So I know Lion Desk does do a large portion of it as well, but it's up to you in order to do it. Stephen, do you have any suggestions on that? I'm still curious and kind of dumbfounded because a lot of times we're right here on our mobile device, and I think other people are as well, as to how do you pull those text messages out of there to keep a record, do it monthly or whatever else.
Yeah, I can identify issues. I don't necessarily have the easiest solution, but
okay.
You definitely would have to. It's not that hard downloading because it took about 10 minutes to download a decent amount of information from the text messages. But I guess my question to you, Ryan, would be, do you think most agents save all their text messages?
I would say no. I mean, some people just don't get as many, I think. But I do believe that, I feel like I'm pretty darn tech savvy. And so it's one of those things where I don't know. Like I said, I clean my text messages out. And yes, people asking, there are different notebooks that are out there and available. I'll reach out to you after the call and see about those as well. But yes, absolutely. Same kind of stuff goes when you keep a hard day timer or day planner, which we do give out each and every year. You can keep notes inside of there. It's a great log for tax purposes as well, especially for mileages and things of that nature, by all means. So what else? Obviously, it's a real conversation. I guess part of the question comes back, and you kind of led to it earlier, like when's it a good time for someone to call you? Is it after they have a problem? You talked about a bunch of proactive kind of ways of being able to have a relationship with a real estate attorney like yourself. I also want to give a shout out to Chris Abernathy on this one. It was kind of wild because we had a client call. Here's something from a title perspective that kind of came into play, and it was an opportunity to refer back to Stephen here. It was a couple that was together for a long time, had kids together, bought a house together. The gentleman decided not to marry, or they decided not to marry. Decided to do a refinance. They were going to pull some money out of the house for mutual benefit, and instead of being mutual benefit, person trumped it into a large portion of a retirement account for the one individual, and then I want to say filed for divorce, but they didn't file for divorce. They were done, Splitsville. So now all of a sudden the gentleman decided to take all the equity out of the house. They were going to sell the property, and the house was only in his name because the significant other had signed off because the loan was only going to be in his name. And it seemed like at the time, it's a harder case to prove because they're not married and it's a civil issue, not a family law issue. And so another friend of mine, Mr. Chris Abernathy, says, I can't do it because it's civil, not family law. But what I would do is I'd go to my buddy Stephen Cho because he's phenomenal at the civil cases and so forth. Obviously, if you're not married and you're living in a house and have kids together, I don't care if you're the husband, the woman, or the man. You know, if you want to have community property and things and rights to those items, it's kind of a big deal because obviously in this case it would come to a civil case, right?
Absolutely. And you know what, surprisingly, a text message in that case would be very helpful because it would show the intent of the parties. Because if you're not married, there are certain presumptions in law and there's certain kind of an oral contract that's at play, and what the terms of the oral contract is going to come out, where evidence is going to control who ultimately, whether it becomes divided, much like community property, or if it becomes a gift or not. So there's different theories that's going to be pushed through. So one of the things that I think even in that example you gave is going to be really contingent upon what the emails, the text messages, what the intent and how you prove that intent. And a lot of times, if there's no evidence, then the attorneys are going to make their narrative the way they want it and fit into the theory of law that they want to push forward. So if I was representing the person that took the entire equity, I would say it's a gift. Prove it otherwise. You wanted me to have...
It makes it very difficult because obviously it's a different kind of case altogether. And it seems like this woman who allowed him to take advantage it's a bad situation altogether. So,
but again, if you don't have the text messages or emails or whatever else it is, what the point that I'm making is that each attorney can put forth their narrative, and sometimes it's very offensive, but lawyers are going to do what they're hired to do. So, you know, to me right now, the biggest thing that I could hopefully get everyone to understand is that California evidence allows for text messages, clearly. And I can tell you that most of the clients that I represent, they are all using text messages, but yet they're not saving anything.
So if you're seeing a general theme here, as we've been talking a lot, obviously we communicate a lot through text message, and text messages these days in general, millennials even more so. So obviously we need to do a better job at being able to download that documentation, which then again reminds me as to we need to figure out what that would look like.
I'll provide you the program that we use so that you can forward it to all your agents that you're working with. But right. But keeping the text message is a part and parcel to a bigger approach and a bigger kind of a standard operating procedure, meaning there's certain issues that I think you have to understand that it's going to come up. It's going to come up where you have to treat every transaction as a potential liability in the future and be prepared to prove up everything you did. Now, if you keep every conversation log, every phone call, every email, every text message, and then even then, issues are going to come up where you can just tell things are going south. And instead of waiting until you get sued, you should proactively reach out, because you know, most of the attorneys that I know that do real estate law, they're not charging for consultation. And sometimes I've had clients call me and say, hey, this is what I'm really concerned about. You know, do you have text messages? Do you have emails? You know, what occurred? How can you prove it? Do you have witnesses? What are they going to say? And a lot of times what we do is by asking them to follow up with the witness, what they saw, and that witness forwards an email. Now you keep that. You feel a lot better going into this because you've done everything you can to prove up that what they're accusing you of, or what it looks like they're going to accuse you of, is something that we can easily shut down right at the beginning.
Now, I think I know the answer to this, but a question came in. It says, if not saving text messages, can you reiterate in an email and send just to be as effective?
Absolutely. And I try to get corroboration all the time. So clients will call me and say, this is what's going on. And one of the first things that we as preventative measure, as an attorney advising a client is, hey, send out a confirming email and see if they'll respond to it. And so sometimes in the email, they'll say, we've talked about this for many, many times. And, I've texted you, I called you, and, we went through this issue and, I just don't understand it. And you lay out your, what occurred. And then they say, I know. And then they don't say anything else. But at least it shows that you can prove the text messages and other things that occurred through that email if you get some kind of corroboration. Now,
Right.
even if you don't get the corroboration, the fact that they don't respond, you can still spin that in a court of law to say if they didn't agree with it, they would have responded. And
Right. Well, that's not a part for those people that still leave their red receipts on. So you can see where it says delivered and or read on most cell phones anymore. So you can see that the person on the other end at least saw. They may not have responded, but you can tell that they have seen or read the message as a whole.
Yeah, so even if you don't have text messages, I think you need to start documenting now, because there's a saying in the law, if you don't document it, it doesn't exist. So
Right.
you want to make sure. And so sometimes you're like, well, they haven't sent anything. Well, you send an email and you tell them
Right.
exactly what's going on and see what the response is. And based on that, you'd be surprised how a lot of good information comes through that way. So just be proactive. And it's like, you can call me, you can call John. There's a couple of other guys that are very reputable in the area. And, figure out who you click with personality, because, not everyone sees the issues the same. Most of the attorneys will in terms of liability, but personality matters. There's different risk that each attorney takes. And
Right.
there's a certain, like my partner and I, for example, my partner is very risk averse. He feels like if the client gets sued, he failed. And I see it as, no, if we lose the trial, we failed. It's a different approach. And so, brokers that I represent, some are very aggressive and they're like, well, if I do what you tell me to do, I'm not going to make any money. I gotta push the envelope. And I said, well, make sure you do this then. Make sure you document this. Make sure, because for me, I don't like dual agency because I think it's a nightmare. And if a lawsuit comes in, whatever profits you made, you might give it back to the insurance company's attorney or to us or to whoever.
Right.
But I have seen a lot of brokers that have done really
So would
well.
you advise, like, for example, that if someone's going to do dual agency, they'd be better off giving it to a partner agent and getting a referral fee from that person?
It doesn't matter. It works the same. If
Does it really?
it works the same under the law. So if you work in the same office, you have the same exact liability. So you might as well.
Really? Even if it's the same office and you give it to somebody else altogether, it still exposes you to that much risk, huh?
Yeah, because the contract is not with the agent, it's with the broker. It's the same broker.
Got it.
So the real estate listing agent, listing agreements and the purchase sales all through the broker. So broker has the contract and he's getting the assistance of the real estate agent. So it doesn't matter. So if you're going to share with another agent, I would just keep it by self, because what's the point of sharing the listing if you're going to have the same risk? It doesn't seem to, you're not reducing your liability.
So at that rate, it's almost like, okay, well then let's not do that. I would have thought that would have given us an arm's length, saying, hey, listen, there's somebody else fighting. We're fighting for each other, kind of deal, and that would be a good option. So.
Yeah, that's what a lot of people do think that, and I tell them, unfortunately, the same arguments that can be made against you if you did the deal yourself, it's being applied here. It's the same effect. So
so again, it just comes back to, even if you're doing it within your own office, that you need to make sure that you overly document what it is you're doing.
Yeah, and if there is some type of disclosure that clearly makes sometimes the argument is, even if all the documents correct, people still get around that by saying, I didn't really understand what I was signing.
Oh.
The agents told me to sign it. They just told me to sign it. I'm not a lawyer, they say. And, like a lot of times when there was an issue that came up, I think this might be relevant, about a year ago, there was an issue regarding how to vest the title, whether it's a joint tenancy or tenancy in common.
Okay.
And so what ended up happening is the property got vested as joint tenancy with the right of survivorship for the other spouse.
Okay.
2 or 3 weeks after the close, they ended up they separated. They didn't file for divorce, but they separated, and they had kids from different marriages. And when one spouse died, the heirs of that spouse said that the agents told them and advised them to pick joint tenancy, and they
That's a great title transition right there for us to be able to talk about what we do. Investing absolutely matters. Joint tenancy means that surviving spouse gets the decedent's portion. So, you know, joint tenancy in most cases for married people is going to be one of the better options, but we're supposed to give that disclosure that we are not an attorney. And so typically what we do is we hand over a copy of the vesting chart to the clients, and we tell the agents all the time, you could tell them how and why you've taken title specifically and what your reasons were, but then give them a copy of the sheet and say, hey, here's where the differences are. You may want to consult your attorney or tax person because there's implications. And this stuff comes about, and I'm not so immune to this deal either because, you know, for example, I lost my dad in 2012. My mom has since remarried, and obviously I have my brother and myself, and her husband has kids of his own from a previous marriage. So, you know, which assets are supposed to stay which side, and how does that matter? And I mean, it's not really about the assets, but it's about what the people's desires are. So vesting absolutely matters.
So in that case, I asked the real estate agent, do you have any emails? Nope. Do you have any text messages? Nope. The allegation is that you just told their parent that passed away that this is the way it's going to be, so you have to do it this way because you're married.
Yeah.
Their word against theirs. But, you know, if you would have had an email saying, you know, I'm not an attorney, you should probably contact an attorney. This is what I would do, but I'm not an attorney, so don't take my advice. And if you had that email and she received it and she says, thank you, would that have saved that agent? Absolutely. Because now they're looking at practicing law without a license now, which could be, because then you're advising on legal issues. And it's something so basic and so simple, right?
Right, absolutely. Now, this, for example, for anybody watching, we absolutely have flyers that do give a full breakdown. And so when I'm talking to you and I'm sharing the stuff, this is one of the things that I am absolutely being very specific on. So we can send you that flyer when you need it, or it's in a home buyer and seller guide. Forward it with similar verbiage as to what we're talking about right here to avoid that challenge, because we just don't know what those other people's scenarios are. And that's one of the challenges that we have had as an industry as it relates to doing accommodation documents. In many cases, words that we were being asked for years, hey, can you create a grant deed, a quit claim, whichever. And so we just do as we're instructed by our clients, and then they have their clients go ahead and sign it. Or even there's been cases where we have had nothing to do with it and we've recorded that document, and then they come back months later and say, hey, well, we didn't approve this, and lawsuits happen. And they say, well, you're a big bad title company and you should have done your research before recording this, so you're liable. And then here it is, we take losses as an industry because people they're looking for an easy out. They're looking for someone with deeper pockets than themselves. And so that's why we as an industry have not done accommodation recordings for at least a year or two.
And the other thing is, I also saw a lot of agents that will go from one broker to another broker, and they don't necessarily keep copies of the transaction that they worked on. And lawsuits come years later. So, you know, it's not unusual for lawsuits to get filed today regarding a transaction that took place in 2017, 2016. Because
so how long should they keep their documentation?
I've kept my emails for 18 years for me. So that tells you what I think about how important. So I have a really large server. I keep everything because you just never know. Because the statute of limitation on breach of contract, written contract, is 4 years from the discovery of the breach. So what that means is that your transaction can be closed 2015, 2010, and now 2020, you realize there's a breach of contract. They have 4 years from 2020 to sue. And then you have 3 years for fraud from the date of discovery.
From the date of discovery?
Yes.
Okay.
So that tells me that the timeline could be really long, and it's scary that I keep everything. I keep files. I'm required by state law to keep files for 5 years, but I have every single file. I don't destroy anything because you just never know. And a lot of
Right.
times what I notice is when agents go from one broker to the next, the transactions that you're working on, you should have a file of that. Because what
Right.
happens if the broker's not available? Or,
Well, technology's made it a little bit easier. I mean, you can buy a terabyte hard drive that you can keep at your house, and everything gets digitized and scanned anymore anyways. I feel like that should make it easier for us to be able to save that information, don't you?
I agree, but text messages, emails, phone call, conversation, that should be all part of the file that should stay with that agent for every transaction that they work on. And if
Got
they
it.
don't, I think you're running the risk because, 5 years goes by or you're, going along, everything's fine, and then you get hit with the lawsuit and you're like, where do I find these? Where's
Right.
my Where's my, I don't even have my phone from 5 years ago. And that's a very stressful place to be when, especially, and I'll tell you, it's very unusual for cases to not get settled early on, because if we mess up or the agents mess up, we pretty much say, look, how do we make this right? And most brokers are of the same mindset. And the insurance companies that represent brokers through the errors and omissions insurance are pretty much the same way. But when it's a he said, she said, where there's definitely not a clean, clear misconduct, then it's going to create stress because, insurance companies don't want to pay unless they absolutely have to. And
Right.
even clients don't want to pay unless they know their agents are in the wrong. So it's really important to have the documentation because it gives you leverage in negotiating. Because I've probably, in the last 15 years, I probably had about 20 cases settled for $5,000. And when the lawsuit came in, it was like millions and millions of dollars of damages. So it's kind of unfortunate, but in those cases, one broker I represent, I won't mention it. I'll mention his name. You might know him, Peter Gattuso, and he's kept good records. And we represented him like 18 years ago, and his agent messed up, and after that, they're on it because they don't want to be in court, and they haven't been in court since 2003. So that gives you some idea about, and that 2003 case was a dual agency case. So,
Okay.
it's kind of a situation where they are very proactive and they have taken the technology, and it's been 15 years since
Right.
that they've been in court. So that gives you some idea of being proactive, and I've been representing them for almost 18 years now. So, and again, I don't charge them very much because I'd be shocked if I bill 2 hours, a month. And, and being proactive really does help. So, but, as an agent, I think it also should open your eyes that you can't just rely on the brokers, because the brokers' levels are all over the place. Some
Right.
are very educated, very diligent, wants to really grow in the industry, and some are not as focused on that. They're more focused on the business end of it. And it'd be a shame to get tied in with a broker where the records are not there and they get hit with the judgment, or they get hit with the restricted license, suspension, revocation. And it just seems like those are avoidable issues as long.
So are you seeing those cases live and active in today's marketplace? Or, well, obviously some of the stuff's still delayed right now because of obviously the courts being closed, but are they revoking people's licenses right now? Because I don't think we hear about it enough to scare people to a degree. And I say it kind of half-heartedly, but I don't think there's enough in regards to publication as to what's actually happening for people to realize that they truly are at a risk.
Yeah, it's out there. It's out there. And I think a lot of the clients that I represent they don't want to publicize it. And I don't think people really talk about it, because at the end of the day, unless you're flat out committing crimes, defrauding clients or something to that effect, it's not gonna really end up causing a revocation unless there's multiple violations. But it's out there. I mean, I have 4 active cases right now in the DRE, and I have 2 active cases with the Department of Business Oversight. And it's literally in the same court, just different attorneys, and it's a rigged system as far as I can see, because the DRE attorneys are buddies with the judges that are there, administrative law judges. The DBO attorneys are friends, and they all work for the governor. It's kind of, it just doesn't seem like a fair system. And you almost have to say, I'm ready for trial, or they don't really make meaningful offers. So I'm not a big fan of the DRE or the DBO for that matter.
Ouch. Okay. That's a bold statement to make.
Just my personal assessment. I hope I don't get sued.
You know, truth is truth, and we figure things out. But obviously, there's a lot of hurdles and landmines that we're navigating in our industry. I know, and maybe you're versed in this. I didn't really give you a heads up on it, but I know some of the challenges people are having right now is some of the real estate offices are trying to find ways of officially opening back up. Obviously, they're an essential business, but my understanding is that the hurdles they have to go through in order to reopen their offices is pretty significant. Are you versed on any of the stuff in regards to that, what that looks like, or if they do, what consequences they might face?
You know, I represent a local gym also, because I know I do employment law and my mortgage and real estate background, but you know, I'm also a lawyer, and if a business wants me to represent them, and right now they're facing a struggle in that he's technically open, and the governor's mandate, as well as the San Bernardino mandate, says you can't be open. And we've dealt with, it was kind of a weird interaction with the county officials, where they're saying, we understand you're open, we just don't want you to publicize it. As long as we don't get complaints, we'll leave you alone, is how it came down. So,
Right.
So it seems like there is some, if you go by the black letter law, he can't open. And a lot of the real estate offices are just like us in that, you know, we have social distancing here in our office. Half of our staff are working from home, and I hate it, but we're going to follow the law because I don't want any issues down the line. But I've had several clients, like this one gym owner in particular, he said, hell with the law, I'm going to do it. And he asked me the question of, what are the ramifications of me opening? And my answer is, I don't really know. I know what the potential fine could be, and it even seems like the legislative intent is that there can be misdemeanor, criminal intent, and things like that. But practically speaking, I don't think it'll be there. And right now, our biggest challenge is to get the banking system to collect fees from the member, because they're adhering to the state mandate as well. And so we're pushing through, and you know, the client knows the risk, but he's deciding to open. So I think it's a question of letter of the law versus the spirit of the law. I think in a real estate office, I think it's probably going to be, I don't want to say less enforced, but I think it's really a question of what type of complaints that come in from the general public. So
see, I can tell you from personal experience that there was a memo that was given out to law enforcement, the agency that I serve as a reserve for, that you know, when this stuff all came down and trying to figure out what it was going to go, they kind of said, listen, we're pulling back. We're not doing proactive policing right now. It's one of those things where we're trying to preserve, keep order, have heavy presence, do our best to distract or deter. That's what I'm looking for. I don't know why it was so hard to find that word, but deter things from happening. And so, you know, I know that they didn't want to make extra contacts with people and extra public that they didn't need to expose the officers to more risk. So, you know, I don't think it's their first assumption that they want to go out and bust people for keeping their businesses open and trying to provide for their families. I completely get and understand that. So no doubt that part from my perspective. I've also had the pleasure of going out and serving on duty with Mr. Stephen Cho here as well, because if you didn't know this, he also has served for a lot of years as a Reserve Deputy for LA County. So we've been able to go out and have a good time doing that. He was originally, I think, out of the Diamond Bar Walnut Station, and now you're out of La Cunada or something. Did I hear that right?
Crescenta Valley, and I think Ryan doesn't want to go out with me again because he doesn't trust my driving.
I can tell you that we responded to a 211 call from one side of Diamond Bar to the other in the dark after it had just rained, and it was pretty impressive. I'll put it like that. It was pretty impressive. But no, not at all. It's not like a stereotypical thing about I'm just throwing it out there. You actually can't drive against the stereotype. I'm not lying on this one here. So
Anyways, to close up, I think it's really about establishing a relationship with the attorney. Like, it's no different than, strategic partnership with Ryan, with other lenders, with real estate. I think it kind of goes hand in hand. And the more you have that relationship, I think the cost is pretty nominal to get that proactive advice right from the get-go.
Well, Stephen, here's something that a friend of mine, friend of yours as well, Rhonda Calipio, and she might still be on this call. She's always kind of said this, especially as she's gotten into it. She kind of does a play on words, and she says many realtors think that they're in business, and they just think that they're a realtor who is in business. But here's the caveat when people start changing it. You happen to be a business owner that happens to be in real estate or in the field of business. So as independent contractors that most people in this business are, we have to be able to protect ourselves and think of ourselves as our own entities that you are as a business owner. And if you owned your own business and took that mentality and that mindset, you would want to protect your assets, your business, your livelihood, those items. And so being able to pick up the phone and have a teammate that can help guide you through that to avoid the larger costs of a lawsuit at some point, because I found that the more transactions people start to do, the more people that they contact, the more likelihood that something's going to come up over time. So it's not that you're scared, it's that you're running your business the right way through the right channels. Is that a fair enough statement?
I completely agree with that. And one thing to add on top of that is that real estate agents have personal liability. So what that means is that and I don't know if any of your listeners or your real estate contacts, if they've actually read the errors and omissions policies that the broker has. If they read it, there's exclusions and there's limitations and what they actually cover. So let's say that in a catastrophic of situations, the damage that was created is $5 million and the insurance only covers $1 million and the broker's net worth was only $1 million. What's going to happen to the next $3 million in the transaction that they were involved in? They're going to look to the agent. It doesn't quite happen very often, but it could happen, and they need to know that, and they need to treat this like their own business so that they could be properly insured and covered so that they're protecting their business. And so, the message of today is how I can help and provide value to them is save everything and treat it like there's going to be a fire, and you get a fire extinguisher and practice the emergency exit and have a family contingency plan, no different than you should do it for your own business and your own practice, and make sure that you have everything dialed in and have the partner relationship so that you can get the help early on versus waiting until the lawsuit comes, because then it's too late.
Right. So I don't have it on here. I don't know if you have a screen or whichever. I can share the screen here in a moment. If you're trying to reach, I can always send the information over. I will also post the recording of this to my website. So if you're interested in that at some point, by all means, please know that you can go back and reference it. I'm going to try and see if I can pull it up here. Any closing thoughts as I try to pull up your website and I don't have a whole bunch of dead space here?
If you guys call, I'll answer, and any way I can help, I'm here to help. So
in regards to you answering your phone and so forth, what is the best number for them to call to try and reach you?
213-700-6653, my cell phone.
Oh, snap. Guys, I'm not lying on this one. I don't give out his cell phone number, so he actually did just give his cell phone number out. So I think
that's my work cell phone. I turn it off at...
So here is their website, CKB Vienna. They have an office here for those who are in the West End. In Rancho Cucamonga, you also have other offices in other areas as well, if I remember correctly as well. I just always reference the one here just because that's what I know.
Yeah, Tony Vienna works out of the LA office.
So There is their information on their website as well. So if you're watching this again and you're trying to see how to reach it, this is the office information. You can replay it back or rewind for the cell phone number that he had given as well. Again, obviously a resource. I reach out to him and say, hey, someone just called me. This is what they need. Here's a quick rundown based upon the information I've been able to figure out. And I think it's imperative to be able to have people in your corner. I think that right now, and as you've heard me talking in the past, I think right now we need to find a way to be the biggest resource we've ever been in our entire careers for our databases in our sphere. And I think there's a lot of misinformation that's out there. So if you're not sure an answer on one of these legal questions, again, we are not supposed to give legal advice. That guy over there, I can't do my thumb right, you see? That guy is the guy you're supposed to call. He's the one that can give legal advice because what was the term you used? Not an attorney practicing law or something?
But we want to do preventative versus, I look at lawsuits like dealing with cancer, and I want to identify the issue early on so that we can eliminate it versus letting it grow into something bigger. And I forgot to tell you one of our clients got sued for like $30,000 or $40,000 exposure or damages, and they didn't settle. And the case ended up where they recovered $300,000 in attorney's fees after a jury trial, over a $30,000 damage. So the defendant could have just paid out the 30 grand and been done with it. But that's an example of, in the real estate car contract, attorney fee provisions are part of the lawsuit. So if this takes 3 years, 4 years, you're probably going to have a $300,000 or $400,000 bill. If the insurance company covers it, great. If they don't, because it exceeds it, then that goes to the broker and the agents.
That's a tough lesson. That's a big lesson to learn. So guys, one of the things I think about and why we've been able to be successful in our careers and so forth is the fact that we build a team that's greater than ourselves. We find strategic business partners that not only do what they say, but say what they do, but do what they say, that are responsive. And we set up these opportunities because I believe that we absolutely have to be able to share the people that we're friends with, that we work with, that are able to come through. I would not have Stephen on this call here today if I didn't trust him and wouldn't use him personally. So please know that this is not a Tycor title endorsement of Stephen. This is a Ryan Orr endorsement because we have to be able to have those relationships, those working partnerships to be able to come through, because life is messy at times, whether we like it or not. So I just want to give a huge shout out today for you giving of your time today, Stephen, to help educate us. I know we just said your phone number, and I know there was a generic email on there before. What would your email, and I'll put it in the post and the share as well, but what is your email address?
SCho@ckbvienna.com.
And you can see CKB Vienna. It's got 2 N's. You can kind of see the whole thing in the background of his screen there. So CKB Vienna, VIENNA.com. So that's SCho. You can see how it's Ryan,
thank you for having me. I really enjoyed the time. And if anyone has any questions, just let us know. We're here to help.
Cool. I'm going to check one last time here. Victoria, if you can hear us. I don't see any other pending questions on there. The one pending question, again, that kept coming up was the question of, hey, what is that tool for the text messages? So I will follow up with Stephen as well to get that information to be able to come back and share that with you, because I'm interested personally as well. So